Okay, Bismillah. We have never had important for Islamic law. There are so many people who come to study Quran or write about the Quran. Like the field of Quranic studies is already crowded, but Hadith is different. Hadith is an exacting science. It requires the exactitude of vigorous scholars, and Jonathan Brown is one of these. I am really pleased that he chose to write about Hadith and Islamic law. But you have not come here to listen to me. You came to listen to him, so I hand you over to him. Thank you very much.
بسم الله الرحمن الرحيم إن الحمد لله وبه نستعين والصلاة والسلام على سيد المرسلين وعلى آله وصحبه أجمعين. Thank you very much for inviting me, Professor Abdul Halim, Professor Mustafa Shah, who helped arrange the trip and invited me, to the whole School of Oriental African Studies for extending the invitation, you for coming, and I want to say that it's really a huge honor to be invited to present in this lecture series. I always assign my students Professor Abdul Halim's translation of the Quran, and so now I'm getting a chance to meet him in person and receive compliments, to which I can only say that I'm, one classical Arabic poet said, we're just worms crawling on the roots of a great tree. That's how I feel. I'm a little worm crawling on the roots of the great scholars who came before me, and I feel like just a little person amongst a great group of scholars who are alive today, and how I ever got any attention is beyond me, but I'll do my best with that attention to be of service to God and to the Muslim community, to the world community as much as I can. This issue that we're talking about is something that is, I think it's on the minds of Muslims very much, and everything I study. Oh, by the way, all those articles have subtitles. Yeah, and the first part is weird, but then you have these very clear subtitles. So I just want to specify that. You notice my red, white, and blue tie, because tomorrow I have to go vote in my state primary. All right. Everything I do and everything I study is really about my own interests, questions I have as a Muslim, as an American, and so I try to answer those questions for myself, and if they are useful to other people, then I hope that my answers help them as well, and I do my best, and I could be wrong, so I'm open to correction. This question is, I'm not going to answer it I will lead to the answer, I think, in my talk, but maybe in the questions I can answer it. I just realized I don't know if I give a clear enough answer. I'll do my best. Okay. I want to start with a story. And it's a story involving the Sultan Nuradin Zangi, the great founder of the Ayyubid dynasty of Syria and eventually of Egypt. And Nuradin Zangi, he conquered the city of Mosul. And soon after that, Mosul was afflicted by a serious wave of thefts, crime wave, theft wave. And the ulama, the judges, Muslim judges are also scholars, Muslim scholars, so I'll say ulama judges. The Muslim judges wrote a letter to Nuradin Zangi saying, please, they said this problem, يحتاج إلى نوع سياسة عفوا. This يحتاج إلى نوع سياسة. This requires some type of siyasa. Siyasa meaning, a lot of times it's politics, but actually, especially when Muslim legal scholars talk about it, it means executive authority. It means the executive authority of the ruler, the person who has the muscle. In some ways, you could think of siyasa as, in Latin, imperium, the ability to make commands and demand obedience and punish for disobedience. Muslim judges, they're just judges. They don't have any muscle. They require the help of the state to implement rulers. They said, this requires a type of siyasa, And he wrote back and he said, I will not help you, I'm paraphrasing, I will not help you because if God had wanted in his Sharia, if God had wanted the Sharia, the law of God, if he had wanted this to include a solution to the problem you're facing, he would have put it there. It's not there, therefore I will not intervene. Nuradin was probably, in reality, very pious, a very pious ruler. And he was, as he understood it, not going to contravene the law of God, which had not provided a solution to the problem that the people of Mosul were facing. So they were left without his aid. Today, this lecture is about anxiety. The anxiety of a tension between the rule of law, especially the rule of law as dictated in Scripture, the Quran and the Sunnah of the Prophet Muhammad, between the rule of law and its scriptural manifestation, its indications in Scripture, a tension between the rule of law on one hand and equity or notions of justice on the other. What do you do when these don't seem to match up? That seemed to be precisely what was happening in Mosul in the mid-1100s. They said, we need Siasa, we need you to solve this problem. He said, this is not part of God's law. And so the injustice you are suffering has no response. That, of course, you can imagine, generated a good amount of anxiety on the part of the people of Mosul. And it generates anxiety, at least it did when I first read this today. In a way, this is a correction, because in my latest book, I actually made a big boo-boo. So until I can get a second edition, I'm going to correct it for you first, which is, I treated this as an accurate understanding. In fact, as you'll see, Nuradin was actually making a big mistake. Nuradin Zangi was grotesquely in the wrong on this point. Why is that? Well, sorry, I should have had this point up. This is a crisis of justice that they're experiencing because the ulama, the scholars of Mosul, are saying people have what's called hukuk. Hukuk in Arabic is rights. Rights. Singular haq, plural hukuk. They have rights. They have right to security. They have right to property. They have the right to public order. These rights are not being preserved. And what Nuradin Zangi said is that is not part of God's law. He did not provide an answer for this problem, and I won't act. In fact, Nuradin Zangi was completely wrong. Really, totally, I feel bad criticizing the dead, but there's a good lesson that comes from it. He was totally wrong. And God knows how many people had their little sacks of coins or camels or pots of rice stolen because he didn't act. In fact, there is in the writings of Muslim legal scholars, and the earliest I've seen them articulate this is in the 1000s of the Common Era, the writing of Abu al-Hasan al-Mawardi, famous Shafi judge of Baghdad, died 1058 of the Common Era. But there's mentions of it earlier, and it's implicit in many of the hadiths of the Prophet, but not as it only becomes an institution really in the 800s. As far as I know, could be earlier, but as far as I know, it really only becomes an institution in the 800s of the Common Era during the Abbasid Caliphate. Its capital was in Baghdad. What Al-Mawardi and others called wilayat al-jara'im. Jara'im is plural, it means crimes, plural of jarima, crime. This is, we could call it a crimes court. But this isn't a court for any crime. This isn't a court for parking, or as my friend just got hit ISBO, is a violation of public order or something. He has a Ferrari and he was revving it too loud. He got this fine in the mail. That's not the kind of crime you're going to go to the Jara'im court. This is serious crimes. In particular, and this goes back to a Quranic verse, the verse in the Quran, hiraba, which is often translated as banditry, highway robbery, not the kind of thing you experience from, in America, like cable TV companies engage in highway robbery. This is real highway robbery, right? Really, especially in the Maliki school of law, first-degree, premeditated, cold-blooded murder, almost assassination, ghila. These are the type of things that the Jara'im court handles. And the Quran lays the seeds for this. The Quran says, إِنَّمَا جَزَاءُ الَّذِينَ يُحَارِبُونَ اللَّهَ وَرَسُولَهُ وَيَسْعَوْنَ فِي الْأَرْضِ فَسَادًا أن يقتلوا أو يصلبوا أو تقطع أيديهم وأرجلهم من خلاف, if I remember the verse correctly. The punishment of those people who make war, same root as banditry, who make war on God and His Prophet and spread corruption in the land, their reward is not but that they be killed and they be crucified and they have their hands and feet cut off on opposite directions. And this verse is revealed in the context of the life of the Prophet Muhammad, when a group of people come from a tribe called the Urayna tribe, and they're sick. I'm not going to get into this issue because it's going to raise too many questions. It involves camel urine and medicine. I'll just skip over that. They're supposed to go and access these camels. Instead, they kill the shepherds and they steal the camels. So they've committed murder, premeditated murder, and they've stolen goods. They are captured, they're brought to the Prophet, and he has their eyes put out, and they're executed. And there's no evidence, there's not any reliable evidence, even according to classical Muslim scholars, that they had their hands cut off, but they were executed. This becomes the Quranic and prophetic basis for the criminal court, the Walayat al-Jara'im. You note that, by the way, the Quran is verse 533. There is no ceiling on the punishment that you can receive, in the sense that you can be executed. As we'll discuss, there is a question of whether or not certain kinds of execution or certain kinds of treatment at the hands of the court can be excessively cruel. And that is one of the areas of tension that exists in this story of anxiety. This was an expression of Siasa on the part of the Prophet. And when later Muslim scholars point to prophetic justification for the criminal crimes court, they point to this incident because it's not seen as something that is within the purview of the qadi, of the judge. Muslim judges in every school of law except the Maliki school of law, and in the schools of law that predominated in Central Middle East, South Asia, Central Asia, the Ottoman Empire, Southeast Asia, it was the ulama and judges said, these crimes are beyond our means, like these crimes were brought to the Prophet, and he dealt with them uniquely, with unique punishments. This is the job of the ruler. This falls under the Siasa of the ruler. It is your job to deal with it. So Ibn Taymiyyah, the famous scholar of Damascus, died 1328, talks about this. In his time, he calls it the war court, the military court, but it's the same thing as Jara'im court. He says this is where cases are taken that would normally fall under the qadi's, the judge's subject matter jurisdiction, but if they're so serious that the qadi can't solve it, like the qadi doesn't have the means to go out and stop these people who are engaging in highway robbery in the city. Doesn't have troops, doesn't have police. And also, sometimes if there's not enough evidence, this is something we'll deal with later as well, which is, in order to prove someone's guilty of murder in Islamic law, you need two upstanding male witnesses. Let's say, what's your name? I know you. Okay. Ikmal. Did I meet you in Malaysia? Oh my gosh, small world. Okay. Let's say he kills somebody, God forbid. Okay. And the only people who see him are a woman and a 15-year-old kid, 14-year-old boy. We do not have enough evidence to prove that he did it. These people are not acceptable in evidence for murder trials in Islamic law. But in another instance in the life of the Prophet, there is a person is murdered. The body is found in one of the Jewish towns in the Hijaz. One of the Muslims is murdered. They don't know who did it. There's a procedure that's of oath swearing that I won't get into, but basically if people swear a number of oaths that these people somebody killed these people in this neighborhood, we don't know who, or we don't have enough evidence to prove who it is, but we think we know who it is, the people who are named as responsible parties, they can't be executed, which would be a normal punishment, but they do have to pay the blood money for the person who was killed. So what happens is, if you don't, that is also done under the rubric of Siasa. This is the Siasa of the ruler. He handles this. So for example, if this becomes the precedent for numerous cases, let's say someone is murdered in, what's the biggest mosque in London? Regent's Park Mosque. Someone's murdered in the mosque, or right at the entranceway of the mosque. No one knows who did it. The ruler has to pay. He's responsible, or the state is responsible. They take on a corporate responsibility. Because what happens in the instance where this man is murdered in Khaybar, or in this Jewish town? The Prophet himself pays the compensation. Because there's not even enough evidence to prove that the people who were accused were guilty. So he himself paid. Okay. The second story of anxiety that I will tell you involves a scholar from outside Shiraz in southern Iran. He is the last great Sunni scholar of Iran. He died right on the verge of the expansion of the Safavid dynasty, which conquered all of Iran, what's now historical Iran, and in fact more than Iran, and converted the country to Shiism. Before that, you had majority Sunni population. Jalaluddin Davani of Shiraz, leading Shafi scholar of law, Ash'ari theologian, and an intimate courtier of the Akkuyunlu Turkic dynasty, which ruled parts of Iran and Iraq at the same time. The Akkuyunlu, the white sheep nomads. These were really your Turkic warlord, your big, gruff, giant lamb leg eating, not showering a lot, not so sophisticated Turkic warlord. They ruled southern Iran, and he was a loyal servant of the dynasty. He writes a very interesting treatise. This treatise is in Persian, and this book that I'm writing now, part of it is editing that text and translating it. He writes a treatise on something called mazalim, or mazalim for you South Asian friends of mine, mazalim, or Persian friends of mine, or Egyptian friends of mine. Mazalim. Mazalim means wrongs or grievances. The mazalim is, you could translate it as a tribunal of wrongs or tribunal of grievances. This goes back to the ancient Near East. The idea that the ruler, whether it's the Roman emperor or the Persian emperor, is the ruler who is the ultimate guarantor of justice in the land. It's the ruler who must make sure that justice is done for his subjects. You could also see this, it's easy to imagine, in the Arab tradition, let's say nomads in pre-Islamic Arabia. Someone, even today, let's say in Saudi Arabia, they actually have a mazalim court in Saudi Arabia, and you can go, ultimately, in theory, all the way to the king and say, I've been done wrong. One of your, let's say, and this isn't just, I'm not talking about Saudi Arabia, but anywhere, it's one of your tax collectors took too much money from me. One of your soldiers came and ran over my sheep with his horse. Or this judge ruled on my case and the ruling was unfair. Or what happens later on is it's also conflated with things like the crimes court. So for Davani, the mazalim court is also the crimes court. It's a place where Siasa happens. It's a place where the ruler or whoever the ruler's representative is can give you justice. What's the difference between a mazalim court and a Jarayim or crimes court and the regular court of a Muslim judge, the Qadi court? What's the difference? The difference is that, for example, the Muslim judge, for the most part, and there's a lot of debate about this, but for the most part, and at least in the understanding of people like Davani and others, The Muslim judge has to rule by his own school of law. So if he's a Shafi, he has to rule by the Shafi school. If he's a Maliki, he has to rule by the Maliki school. If he's a Hanafi, he has to rule by the Hanafi school. The judge has restrictions on him that prevents him from pursuing his own agendas. So, for many Muslim schools of law, the judge cannot rule based on his own knowledge. So let's say, Ikmal, to use you again, I see Ikmal outside, and he has got a gigantic bottle of Beefeater gin, and he's just chugging it. God forbid, Ikmal would never do that. I'm the judge. Someone brings Ikmal to court and says, Ikmal has been drinking intoxicants. But we don't have any witnesses, only one witness. It's insufficient. I saw him do it with my own eyes. According to many schools of law in Islam, I can't rule against him. Why? Because the fear is that, what's to stop me from just saying, Omar gave me this nice book. He's a very nice young man. But he's not quite nice enough because there wasn't a big fat wad of pound notes in here. So I bring him into my court and say, I saw you do this, I'm going to convict you of a crime. So these restrictions are placed on the judge to prevent him from abusing his power, to protect the rights of the innocent or the wrongly accused. Sometimes that means that people who are accused and in fact are guilty might not be convicted in the Qadi's court because those restrictions prevent the Qadi from ruling for conviction. So for example, the scholar Mawardi I told you about, the 11th century Shafi judge in Baghdad, he had a very strict, it wasn't just his school of law, but he really was very formalistic in his rules of evidence. He really stuck to the formal rules, not the, let's say, spirit of the law. So, if you have two upstanding male witnesses to something, that is evidence. If the opponent, the defendant, let's say, does not have two upstanding male witnesses, if he only has an oath or not enough evidence, the people with two upstanding male witnesses win. He is in a debate with people from the Maliki school of law. They say, if you have 100 witnesses, all of them upstanding, reliable people on one side, and 2 witnesses on the other side, obviously the 100 people beat the 2 people. I mean, everybody would know that. You would sit there and be like, obviously they're telling the truth. Mawardi says no. 2 people is like 100 people. God gave us these rules. I don't care what makes your heart feel more rest with one side or the other, what's more convincing to you. These are the rules from God. The people in the Maliki school said, if there's a dispute between a married couple and they want to get divorced, the husband says, we never consummated the marriage, we never had sex. That means he only has to pay half the dowry back. He only has to give her half the dowry, he doesn't have to pay the full dowry. If they have sex, he has to pay the full dowry. How are you going to have evidence of this? Their words, there's no witnesses, at least we hope not. Right? There's no witnesses. In the Shafi school, the assumption, again, sort of formalistic. We know for sure before the marriage they hadn't had sex, and we have no evidence to prove that they had sex. Therefore, the default is to what happened before. The man only owes half the dowry. The Maliki, people from the Maliki school arguing with Mawardi said, that's absolute nonsense. This couple's been married for a year. Everybody knows what people do when they're married. The safest assumption is that they had sex. It's unfair. You're robbing this woman of her haq, of her rights, if you don't go on the assumption that they had sex. Again, Mawardi says, we have the rules of evidence, they're very clear. What you think makes sense doesn't matter. Davani says something very interesting in this treatise, this Persian treatise he writes. His whole treatise is describing this institution of the mazalim court. And he tells a story, he says is the prophetic example in the life of the prophet, which is the prophet's, a Muslim named Zubair ibn al-Awwam comes to the prophet, and he's having a dispute with a man who owns land right next to him, farmland right next to him. They're disputing about who gets water, sharing the water. The prophet says, okay, Zubair, take enough water and a certain amount of water, and then let it go to this guy. And the man says, oh, prophet of God, you're ruling on his behalf because he's your cousin, or yeah, he's one of your cousins, one of your relatives. The prophet gets angry and he says, now take twice as much water. That was executive decision. The man had spoken disrespectfully to the prophet of God, which, by the way, normally would have been, this person would have apostatized. So this is actually an example of the prophet. He doesn't ever punish people around him, even when they do acts that today would be really horrible. I mean, people would be so angry if someone said that today. He just deprived the person of a little bit of water. He acted as sort of like a judge today, giving fines of contempt, or giving a lawyer, a disrespectful lawyer, disrespectful party in the suit, contempt of court charge. And then he says, anybody who says, Davani says, anybody who says that the mazalim court is not legitimate, na mashru', has said something illegitimate. In fact, what they have said is kufr, it's disbelief. They have said something that's like saying God doesn't exist. They have engaged in disbelief by saying this. Because the prophet, he says, the prophet of God himself engaged in this siasa of hearing wrongs and dealing with people as he did in the case of Zubair and his disputant. What is going on behind this? Why is Davani defending the mazalim court? And why is he saying that if you say this is illegitimate, you've actually said something that's beyond heresy, it's actually disbelief? I'll explain to you what I think the reasons are. And it's the same reason, or similar reason, to why Nuradin Zangi misunderstood what his duties, his Sharia duties were as a ruler. When people talk about the Sharia, Muslims talk about the Sharia, oftentimes they're thinking about the Qadi's law. The Qadi is the judge, the Muslim judge, the normal Muslim judge. The Qadi's law is elaborated in this giant discourse called fiqh, or Islamic law, the substance of Islamic law, the stuff of Islamic law, all the rules, all the discussions, all the debates, all the schools of law. And this is often what people think of, this is what people think of as Sharia. This is Sharia. If you go to a book of Islamic law, this is what you'll find in the book of Islamic law. You won't find mazalim in the book of Islamic law. A lot of times you won't find jara'im in the book of Islamic law. You'll find the law the Qadi deals with. But that's not the only manifestation of the Sharia. There's all these other areas as well. One of them is called hizbah. Hizbah is basically public order policing, or public morality policing. It's really especially market policing. A scholar who's appointed to go around and basically make sure everybody's not selling, flour instead of baby formula, not selling, like in Egypt, batteries that last for exactly 10 seconds. It's actually batteries that last for whatever, a week. Sorry, Egyptian people. And Malaysia says, so the market police, making sure everybody's trading fairly. And if someone's got, a really loud oud concert going on in their house or something, or in the shop, he goes and he breaks up the little party. He says this is inappropriate. In theory, if people are selling paintings or statues that they're not allowed to have, Omar, you once told me about that great book, no, I told you about the great book. I get credit here on this issue. Jara'im we already talked about, mazalim we already talked about, taxes on the army. Ulama, Muslim scholars, Muslim legal scholars, always acknowledged that things like taxation and the organization of the army, this is all the ruler's job. This is all siasa. Muslim scholars have no impact. As long as the ruler isn't putting, taking half your money in taxes or something like that. As long as it's not exorbitant, then this is the job of the ruler. Also, today things like traffic signs, speed limits, administrative law, this would all fall under this category. Things that ulama always said, this is the job of the ruler. Now, that doesn't mean that there's no fiqh on these things. The rules of Hizbah come from jurists. They also come up with this fiqh. Muslim scholars come up with this fiqh. So the fact that, let's say, producing little statues of Pharaoh and selling them in Khan al-Khalili, this would be technically against Islamic law because Muslims aren't supposed to manufacture and buy and sell statues, right? So in theory, the person doing Hizbah would say, okay, these statues got to go. Sorry. The jara'im and the mazalim in taxation, they also have a little bit of fiqh, a small layer of, because people have basic rights. They have their basic hukuk in the Sharia. So I said before that in the mazalim court, in the jara'im court, the crimes court, the judge isn't constrained by madhabs. He can go pick whatever madhab. Actually, I don't think I finished that sentence. That's really unfortunate. That's one of the features of the jara'im and mazalim is that the judge does not have to follow any madhab, any school of law. They can pick and choose from different madhabs based on what is best, what they think is best. So in let's say the Maliki school of law, you have much more flexibility on witness judging who's a reliable witness or which side in a dispute has more compelling evidence. So the judge can take that, the Maliki school of law, instead of the Shafi'i school of law, which we discussed is more formalistic. But you can't do something that is unacceptable in all the schools of law. You can't just bring somebody in. Somebody says, this guy stole my car. I said, okay, I'm going to have you beaten and take $50 from you, I'm going to take your car and give it to this guy. You can't just do that. You have to have some evidence. People have a basic right to property. They have a basic right to due process. So there are basic rights that are preserved, and these rights are articulated by the Muslim jurists in the same fiqh discourse that you see that makes up the Qadi's law. But jurists don't talk about what level of taxation is okay. Sometimes they do. But in general, they would say that the ruler is the ruler's prerogative. They don't talk about how the army should be run. This is the ruler's prerogative. If someone says that, let's say, one of the Ottoman sultans had a question, which is, I want to exchange a large number of Christian prisoners that I have for a small number of Muslim prisoners. He went and asked his scholars, and they said, this is acceptable. This is acceptable within the different schools of law. Someone thinks this is okay, so you can do this. So there's still some reference to fiqh, but it's generally up to the tremendous amount of discretion to the ruler. Now, this is all Siasa. But, as I said before, oftentimes when people think about Sharia, they think about what you find in a book of fiqh or Islamic law, and you don't find any of this stuff. No jara'im, no mazalim, no taxation, very little hizbah things will you find in a book of fiqh. But, in reality, this is the Sharia. And this is what Davani was saying. If you say that mazalim is not the Sharia, you have made a mistake. You've made a grave mistake. Because without the jara'im, without the mazalim, without the hizbah, we cannot protect the rights of people. The people in Mosul had a right to be safe from thieves because the Sharia guarantees the right of property. Some of the examples that Davani gives in his treatise that he saw when he was in charge of the mazalim courts in Shiraz were people who had been murdered and there was no witnesses. They find a body and they suspect somebody did it, but they can't do anything about it. So they brought the people in and they interrogated them and they confessed. These things you couldn't do in a normal Qadi court. People who are murdered their families have a right for justice. And if you don't accept these other parts as part of the Sharia, you don't accept Siasa, you are robbing people of their Sharia rights. These are part of the Sharia. So this is one of the sources of Siasa, which is that people think that this is the Sharia, whereas in reality, this is the Sharia. Why might there be so much anxiety? I just gave you one example, which is people have a misunderstanding of the nature of the Sharia, but that's not what's happening with people like Nuradin Zangi and Davani in his very serious statements. There's more going on than just this misunderstanding. One, and this is very important, after 1250, when the Mongols invade the Middle East, 1258, they sack Baghdad. And from that point on, well, first you have the Ilkhanid Mongol dynasty, then it breaks up and you have things like the dynasty of Tamerlane, which is also a Mongol dynasty, and you have the Akkayunlu and the Korakayunlu, and then the Ottomans who are also a Turkic dynasty. From that point on, the legacy of the Mongols is part of the Muslim world, at least the Eastern Muslim lands. What is that legacy? Before the Mongols came, there was no Muslim ruler who felt that he had some justification to rule that went beyond the will of Allah, the Muslim conception of God, and the Sharia. The Mongols originally, they converted to Islam after the late 1200s, the early 1300s. The Mongols who ruled the Muslim world all became Muslim. But they didn't conquer the Middle East because of Islam. They conquered the Middle East because of the great sky god who had given the right of universal empire to the golden family of Genghis Khan. And it was descent from Genghis Khan, the dynasty of Genghis Khan, that had its own power, its own legitimacy. Never before had this been seen in the Muslim world. An alternative notion of legitimacy, outside, totally outside of Islam. And even after they became Muslim, for example, Tamerlane, everybody knows of him, died 1405, the undefeated, many-time Oscar winner of Turkic Conqueror of the Year awards, undefeated, conquered India, Central Asia, defeated the Ottomans, everybody. His descendants, even though he was technically Muslim, as a central Muslim, they didn't rule by the Sharia. They ruled by what's called the Torah, not the Jewish Torah. Torah is his family's version of the Mongol law. And it was applied in what's called Yarghu courts. Don't worry about how you spell that. They applied Mongol law. It didn't have almost no rules for witnesses, almost no rules of evidence. You could have people executed on the spot, no due process, immediate seizure of property. And it was only under the son of Tamerlane, a guy named Shariʿah, not the famous actor, but that's who he's named after, Shariʿah, who in 1411, he abolishes these Yarghu courts. And he says only the Sharia will rule. We'll only rule by the Sharia. But there's this incredible anxiety amongst Muslim scholars from that point on. And this Turkic Mongol legacy goes all the way into the Mamluk realm of Egypt and Syria. And this huge anxiety that Muslim scholars have about the idea that people, even if they're Muslim rulers are actually ruling with some other notion of law, some other notion of law that's outside of Islam. To the extent that they say, one Muslim scholar, al-Maqrizi, in the 1400s says inaccurately that the word Siasa actually comes from the Mongol word Yasa, which is the law of Genghis Khan. It's not true. It comes from Sa'is Yasusu, which is the person who leads the horse, the groom of the horse, to lead somebody. But correct, right? Or not? Okay, hopefully it is. He's not going to embarrass me. But it's not from Yasa. It's not from the Mongol law. But there's this tremendous anxiety that Siasa is really this creeping Mongol law that's coming in. So there's great suspicion of it. So when someone like Davani is saying, if you say Siasa is illegitimate, you've said something terrible, he's responding to all those people, all those Muslim scholars who are suspicious of the ruler using executive authority to resolve situations of injustice. There's also abuse of Siasa. And the Mamluk rulers of Egypt and Syria, the Mamluk dynasty goes from around 1260 to 1517, Egypt and Syria. These people, they were basically, Turkish or Circassian Turks taken as young boys, trained as warriors in Cairo, as slaves, and they're freed and they become the bodyguards of the ruler. Eventually they just take over and they become their own self-reproducing dynasty of slave soldier bodyguards. It's like, a bunch of bouncers taking over, kicking out the whatever, Beyonce, saying you're not here anymore, we're running the show. And they just, same attitude. These people were very violent a lot of the time. Standard punishment, if you really didn't like somebody, cut them in half, stick the top body on a pile of lime and watch the person scream and yell in agony. This was also something that Muslim scholars were concerned about. They were concerned there might be some abuse of due process. So they will distinguish in the 1300s and 1400s between good Siasa, which they encouraged very politely to the Mamluk rulers, please use good Siasa, and bad Siasa, which is the abuse of executive authority by the ruler. So there's the bad reputation of executive authority is also because some Muslim rulers were abusing it. They were depriving people of their Sharia hukuk. What is also behind all of this is this tension we talked about at the beginning. A tension between the rule of law, the idea that there are a certain judicial system. And in this case, it's a judicial system that has been defined by the Quran, the precedent of the Prophet Muhammad, the scholarship of Muslim judges and Muslim jurists. So Muslims are tremendously invested in this rule of law. They believe it originates with God. Certainly it's shaped by human minds in its details, but it originates with God. As Nuradin Zangi said, if God had wanted there to be a legal solution to this in the Sharia, he would have given us one. Of course, he was wrong. There was one. He just didn't think about it. But that same, think about the example of Mawardi. When Mawardi says, it doesn't matter, 1,000 witnesses are the same as 2. It doesn't matter if you think that's unjust. These are the rules God's given us. There is a tension between the rule of law and notions of equity or justice that are outside, maybe deep down. Something seems wrong to you. Those Maliki scholars, they knew it seemed totally unacceptable that 1,000 people are equal to 2 people. What are these? What is this thing that forms a lump in your throat or something? What is this notion of justice that you feel uneasy with the rule of law as defined in the scriptures of Islam? Where does it come from? Part of it is just your local culture. So, for example, people in Europe think it's something wrong with women wearing headscarves, putting headscarves on their head. Why? It's just a piece of cloth. Other parts of the world, people think it's weird not to have a headscarf on your head. Americans think it's weird if you go to the beach, if women go to the beach and take their tops off. American teenage boys like it, but Americans think it's weird. French people go to the beach and take their tops off. Americans think it's insane to eat dog meat. People in China don't think there's a problem eating dog meat. There's some notions of justice that are just differences in culture. Let's not talk about that. What else is going on? There's this notion of adl in Islam, in Arabic. Adl is evenness, equity. Adl is when the 2 halves of the camel load are equal. Things are fair. There is notion of what's called al-aslah, what is best in the best interest or for the good of somebody. This is also the word maslaha. So, for example, what is the difference between the judge in a mazalim court and the qadi is the mazalim judge can rule, can pick from whatever madhab, whatever school of law he wants, in order to get the aslah result, in order to get the best interest result, maximize the good. The qadi, in theory, can't do that. Just like, now in America, we have this great TV show on the O.J. Simpson trial. You guys know about O.J. Simpson, right? Okay, the juice. Anyway, recreating it. I was in boarding school without a TV at the time, so I missed it all. And what's what's behind the O.J. case? Everybody knows he did it, but he wasn't convicted.
Very good.
Justice was not done. Or according to the African American community, black people had been suffering for too long at the hands of the LAPD, and it was about time that one of them got away with it, just like all the white people get away with it. Justice was not done on both sides. We see this all the time in movies when the system fails. You have to stick by the rules of the system, but sometimes the system fails. That's, the mazalim court can rectify that situation. All of these things, one of them is called takhayyur. Takhayyur is when the judge can pick between different schools of law. Darura is necessity. If you have takhayyur, the ability to pick between schools of law, and necessity in Islamic law allows you to do things that are otherwise prohibited. If you take these two licenses, what the mazalim judge can do, you can achieve a level of flexibility that allows you to supersede the normal restraints on the judge and achieve justice as a result. That's the function of the mazalim court and the jara'im court. Yeah, I know I'm almost out of time. I just wanted to briefly discuss, one more thing. So what are the possible responses we've seen that Muslim scholars had to this tension between rule of law in Scripture and senses of justice or equity outside of Scripture? One of them was to respond as Mawardi did, that say, look, your sense of justice doesn't mean anything. I know you think this is unfair, but these are the formal rules of that govern the judge's behavior. This is what we follow. Formalism must, if God had wanted us to have different rules of evidence, he would have given us different rules of evidence. So that's one response. That's a very small minority response. Another response is it's the spirit of the law, not the letter of the law that matters. It's function, not form, that must be supreme. So a great scholar in the mid-1300s named Ibn Qayyim al-Jawziyah died 1351, Common Era. He wrote an entire big fat book. One purpose is to say that wherever there is justice, there is the Sharia, there is God's law. And if you are not giving justice, you are failing in your Sharia duty. If you have some violent criminal brought in and there's not enough evidence to convict him and you let him go and he goes and commits more crimes, you have not done God's will. So remember I said that if I don't know, I can't rule by my knowledge, even if I see Ikmal committing a crime, God forbid? Ibn Qayyim al-Jawziyah says that's nonsense. The judge can rule by his knowledge. If he knows something is true, he can immediately rule. Finally, and this is the option that was most often taken in Islamic civilization, a negotiated compromise. One would be that you relax the rules temporarily. This is done, for example, after the 1300s in the Maliki school of law, in the Hanafi school of law, which is you say, let's say normally we only accept upstanding witnesses with good characters. It's very hard to be an upstanding witness in Islamic law. You have to pray your extra prayers. Not only do you have to pray all the 5 daily prayers, if you don't do the extra prayers regularly, you're not an upstanding witness. You're never going to get, no one's going to get married. No one's going to get committed to any crime. But they say, because the conditions of our time are so deteriorated from the past, we will drop these requirements. This is necessity, darura, and this allows us to do this. We have to do this to maintain justice. The other one is you create alternative venues, like the mazalim court, like the jara'im court, where these rules are relaxed, and it's the ruler's executive authority that makes the decision to guarantee justice. Thanks very much. Exactly 45 minutes.
Very good. Thank you, excellent speaker. This young, eloquent American speaker brought you all here at this end of the day hour and kept you captivated for nearly a full hour.
Was it an hour?
Yes, it was.
Man,
Nearly an hour.
Really?
And he even made you laugh.
Maybe my watch was slow or something.
He made you laugh a number of times. This is the best a speaker can do.
I also do weddings and bar mitzvahs. So.
Thank you very much for this. He has kindly agreed to answer some questions. We cannot have 320 questions this evening. We'll only have a few, and I invite question.
This guy had his hand up.
Please be brief and to the point.
It's like mixture of a personal and other question. One, just as we started direct on Wikipedia converted to Islam in 1997.
Hmm?
You were born.
Wait, why is this about my personal life?
No.
I mean,
Just,
it's not
just because
interesting
the
to anybody.
name, because there's this very famous Indian composer, Allah Rakha Rahman, A.R. Rahman. He was born and then he converted to Islam and then he adopted Sufism. And his songs, like all over the world, he went and he won, of course, Grammy and Oscar. They bring the kind of this equity and peace to the mind which you're talking about within the whole of Islam, which he actually advocates. That's one point which I was coming down to. Secondly, as a student of Islamic law and human rights, our Professor Masood Badrin also always talks about that either we can adopt a harmonistic approach or we can adopt a contrarian approach.
Haroon's
Harmonistic approach as...
harmonistic approach,
Yes, that everything you see in a perspective and it falls like something which you have done throughout. Like this was one of the best, I would say, class of understanding all throughout. Like 6 months made sense right now. So thank you so much. The question
So,
which
I mean,
was just...
I understand the questions, I think. One, Sufism is great. I like Qawwali as much as the next guy. But you can't run a country with Sufism or, well, actually the Safavids did, but I mean, it doesn't work very, you have to have, people got to have courts, you got to bring people who would park their car illegally, you got to do something about it, right? So Sufism is wonderful, but it's not a profession. I mean, it's not a legal system. Although there's all sorts of fascinating questions in the intersection between mysticism and law. For example, what happens if I mystically transported by God to Mecca, I come back, but I'm 5 minutes late for my class? Or what happens if someone dies, God brings them back to life, but their inheritance has already been, their estate has already been distributed? Violations of the miracles do not influence law. Miracles can happen according to Muslims, but they have no legal weight. Sorry, you were miraculously transported to Mecca, but you were 5 minutes late to class, so you get penalized. Your estate is, you died legally, your estate got distributed, sorry. Okay, the second question about human rights, and I think it's an interesting question because I talk so much about hukuk, and that's the translation of human rights in Arabic is hukuk al-insan, rights of man, rights of human beings. There's a big difference because in the Sharia, the Quran doesn't say what these hukuk are, these rights are. The Sunnah of the Prophet does not say what these rights are. These are abstracted, inducted by Muslim scholars over the first 3 or 4 centuries of Islamic law. And until you get really articulate, discrete discussions of this in the 1000s of the Common Era, as early as I've seen it, but maybe there's earlier, I'm happy to be corrected. And they talk about the 5 basic things that have to be protected in the Sharia: the right to property, right to life, right to reason, right to religion, right to family. Yeah. These are different from like what we would think about. Right to religion doesn't necessarily, doesn't mean you can get up and say, as a Muslim, get up and say, Islam's a terrible religion, Muslims should all, that is not going to be good, it's not going to be allowed by Muslim scholars. Doesn't mean total freedom of religion, but what it means is religion has to be protected. In this case, Islam has to be protected against open acts of heresy and things like that. But also Jewish people who are living under Muslim law, Christian people under Muslim law, they have their religions are also protected. Muslim scholars have to protect them. Muslim rulers have to protect them. The difference between this and human rights is that these are not expandable infinitely. So, for example, a lot of people today believe that the right to engage in relationships, sexual relationships or marital relationships with people of the same sex, it should be a human right, and regimes or states that don't allow that should be seen as in violation of human rights. Most Muslim scholars would not accept that as a human right. There could come a time when free refills at restaurants is a right, is a human right. I mean, in theory, someone could say this is a human right, and if everybody agrees it's a human right, then countries that don't provide free refills at restaurants would be a violation of human rights. So the point is that for Muslims, this is not for Muslim jurists, this list is not infinitely expandable, and it's not subject to democratic or consensus building. There's a set number of rights that come from the revelations, and those are the rights that Muslim scholars are. Now, I'm sure they could shoehorn some rights under some of these rights, creatively.
Here's some more question.
Yes, go ahead.
Brief.
Oh, my answer is too long. I'm going to be shorter.
Professor Brown, when I was listening to your lecture, I was thinking about the history of English law. And in English law, common law, using the word common law in its strict sense, when it was found that you couldn't get justice for certain purposes, we developed the concept of equity. But what then happened was that the rules of equity themselves were developed in enormous detail by English judges.
Yeah.
In the Muslim majority world, the development of equitable principles outside what I would call Qadi fiqh doesn't seem to have gone the same way in terms of developing details, procedures, rules, formalism. Can you think of a reason why that might be?
This is a very good question. It warms my heart because it's what I've been thinking about a lot. So, I mean, first of all, there's a debate, I think, amongst common law jurists about do the maxims of equity originate in common law? Are they taken from ecclesiastic law? Are they taken from Roman law? So if they come from common law and are simply rephrasings or something like that, or different applications, that's different from, let's say, totally separate development of law, body of law. In the Islamic tradition, you're totally right. There is no mazalim law. What there is flexibility within the existing pluralism of legal schools of law, right? So you have this sort of giant grab bag of law, and instead of being restricted to one category, one school of law, you can take from any school of law. So you don't need to develop a new body of law because you have this massive legal heritage out there. Not just common law. It's not like just the law of the people of England. You have this massive body of law. Expand, from Malaysia to North Africa, conceivably that you could draw from. And so that's why I think it's more that you just have these principles of, best interests, pursuing the good, protecting rights, looking at necessity. These will just guide you in the choices from this huge legacy. That's a very good question. Thank you. This young lady, is that, or someone, or are you, oh, she's maybe has the microphone. Okay, I see.
Assalamu alaikum, thank you for your lecture. Just in terms of the last slide in your presentation, there were a couple of questions I wanted to address to yourself. Firstly, when you referred to formalism, could you draw an analogy or comparison between that formalism and the formalism that existed within England in terms of in the time of Jeremy Bentham when there was a whole concept of formalism as well? How would you compare the two, compare and contrast?
I mean, you have
Yeah, and just secondly, in terms of the second function, which was functional, when you mentioned scholars like Ibn al-Qayyim, etc., was it their position, because of his theological stance on tahsin and taqbih, that was more or less, he was trying to get to the underlying function, but saying you have to be equally true to the letter and the spirit at the same time?
Yeah.
That's more.
So this is two excellent questions. When I talk about formalism, so legal formalism, when lawyers use the word formalism, it's always a bad word. Formalists are people who don't think sophisticatedly enough about the issue, at least it's not the way you want them to think. But formalism is important because if you don't have a consistent application of law, it means people get treated, everybody needs to know they're going to go to court and get treated the same as everyone else. There needs to be predictable law, otherwise companies don't know if they can sell cars to Iran because they don't know if they're going to get prosecuted. So you need to have formalism for consistency and for predictability of results. That's how one of the ways you measure rule of law is predictability of outcome. Common law was just chock full of questionable, we had it too, so questionable formalism, the time of Jeremy Bentham in the early 1800s. Things like, if you have a tort claim between two individuals, so I run into Professor Mathrudi's car in the middle of nowhere, there's no witnesses except both of us. Neither of us can be witnesses in the case because we're both interested parties. We can't testify. You can't have written evidence. Actually it's interesting, kind of like, Islamic law was actually not that. They did plenty of written evidence in Islamic law. But you can't have written evidence. In equity, you had written evidence. In equity, people could be witnesses. And so what happens in both the UK and the US, as you know, is that these two things get merged late 1800s, early 1900s. And so now you have equity and law together. The second question about Ibn Qayyim al-Jawziyah, which is a really good point. So he says in his book, he says, he objects to formalism. He objects to people who are not going to convict a violent criminal because they don't have enough evidence, right? He says, wherever there is adl, wherever there is justice, فَثَمَّ Shariah Allah. There is the Sharia of God. Now, okay, I could say that today we know it's unfair. It is unjust for a daughter to receive half the share of a son as inheritance. It is unjust for a gay couple not to have exactly the same rights as a straight couple. I bet you $10, if Ibn Qayyim al-Jawziyya heard you say that, he would say, whoa, no. I don't mean that. But the problem is if you take just that motto he starts out with and you apply it without constraints, you'll get a completely conventional notion of justice that's not rooted in any revelatory constraints, but is just based on local custom and developing culture, which a lot of people are fine with. But I think the vast majority of Muslim scholars would say, no, there's certain basic restrictions that you have to follow. But then you would ask Ibn al-Qayyim, what happens if those basic the rules of evidence are not something that stupid Muslim scholars just come up with because they feel like having a busy day of writing. These are in the Quran and the Sunnah of the Prophet. How much clearer can you get? By what right do you overturn these? So this is the tension that's created in his claim is that you can't just go for formalism. You also have to, for functionalism. There's also formal constraints, and then you're just drawing a line between the two, and then it's a matter of where you draw the line. Nuradin Zangi drew a line. It was in the wrong place. Other people drew a line. It was in the wrong place. People are going to disagree about where that line should be between these two poles of formalism and functionalism. His hand I saw before, sorry. I didn't mean to. I know you have a question, but I saw his last time. Yeah.
I was quite interested to know about the role of ijtihad, because during the Islamic history there was a point in time where ijtihad was suspended. And was that maybe one of the factors why in the cases that you cited, Nuradin Zangi might have taken a more kind of puritanical view as opposed to being more kind of adaptable and flexible in his outlook, and then adapting to a new scenario based on the text that was already out there?
Actually, sorry, bad question.
Was it bad?
We have a bad question, folks. I don't mean to. This is something that's been discussed a lot by scholars in Islamic studies, history of Islamic law. So this idea that there's a closing of the gate of ijtihad, this comes from, in the 1600s, some Ottoman scholars use this phrase. And then it gets picked up later by Western scholars, and they assume that at a certain point, Muslims it's like they turn their brain off. Okay, no more. They're always, look, first of all, gunpowder didn't exist at the time of the Prophet. Tobacco didn't exist at the time of the Prophet in the Eurasian world. Cell phones didn't exist. Muslim scholars have been making rules about this stuff looking back, so they're always doing ijtihad. They're always doing interpretation. But the difference is, what they meant is you don't have creation of new schools of law, and arguably in the Hanafi school of law, because they're pretty strict, they don't want you going outside the established authorities in the school of law. You have to pick one of their opinions. If you have a new issue, you can come up with a ruling for it, but for existing issues, you can't come up with any new answers. So it's not so much about the end of interpretation, because interpretation never stops, because new situations are always arising. And new situations cause us to reevaluate old rulings, because maybe necessity has created a new situation, the desire for achieving some social good leads us to take a different ruling. But the idea that the door of ijtihad is closed is more an attempt of Muslim scholars after the 1300s to limit unlimited expansion of the number of rulings.
Very good.
Yes, the gentleman with the glasses that I met earlier.
One or two more.
Sorry.
One or two more.
Many questions, too many long answers. Keep it short.
Thank you very much for your lecture, Professor Brown. I read recently a very, very good article by George Harani, who did a Quranic analysis that made a case he thought for the Mu'tazilite position being the correct Quranic one, which was to say that the Quran presupposed an ethic of natural justice Otherwise, the ideas of justice that the Quran's introduced to the pagan Meccans wouldn't have made any sense to them at all, because they had to have some sort of presupposed idea of what justice was in the first place. So would you tend to agree with that position, that the Quran presupposes some idea of natural justice that presupposes divine law?
That's an interesting question. I think that the Quran uses words like adl, which we talked about as sort of evenness, equity, qist, again, even scales. And then the Quran talks about ma'ruf, what is known to be right, according to conventional understandings of right. So it's ma'ruf, for example, that I tip the waiter 20% in America, but I don't know what it is in England. So that's ma'ruf, urf. None of those are substantially consistent, essential notions of justice, right? They're either relational or they're conventional. When you talk about natural, I think the reason that the majority of, at least certainly Sunni scholars, the majority of Sunni scholars rejected a natural law approach to justice is because it doesn't explain the diversity of human experience. Why is it that, I had to use this example earlier, why is it if you give an American a plate of dog meat, this person will throw up. It will be like the most unnatural thing you can offer them. If you tell somebody that a 53-year-old man married a 9-year-old girl, in America, people will think this is they will be physically revolted. There's other places in the world people eat dog meat. There's other places in the world where you have marriage between very young women and very old men, and this has been going on for many thousands of years and continues until today in many parts of the world. Human beings who are just as smart as you and me, just as human as you and me, have completely divergent ideas of what is just or right in different situations. So Muslim scholars, I think one of the reasons that they didn't stick to a natural law conception is that there is nothing for them consistent in human nature that gives you a consistent idea of what's right across cultures. If, let's say, human beings all love their parents, like human beings are born, they want to be around their parents. Parents love their children. That's a species feature of the human race, so it is natural law in that sense, but that's just like human beings have 2 arms and 2 legs. It doesn't give you a normative, it doesn't give you a moral position. It just says that human beings have this tendency. So I think they didn't see anything, not like the Romans who said there's jus gentium, everybody must think that this is the right way. Muslim scholars lived in too vast an empire. They saw people with totally different customs. And like Al-Ghazali says in his Ma'yar al-Ilm, he says, if a creature came from another world to this world, there's nothing that creature would, there's no reason, there's no external moral reality that makes this creature know that killing a human being is wrong. You just kill a human being, then it doesn't know that it's wrong. If it's natural law, if there's something, or if there's a law that exists outside of human beings, a moral reality, then this alien would know that. So they were very skeptical of the sort of natural law argument.
One more, if there is.
Okay, this young lady up there.
Mm-hmm.
Just picking up on your point about women not being reliable witnesses in Islamic law, I just wanted to know the reasoning behind that and whether that stance is still applicable today.
So I'll give you my opinion. The 4 Sunni schools of law would all say that women have, so in the Shafi'i school of law, they're only allowed as witnesses in cases of contracts and wealth and property and things like that. And in situations when there's no, like in child's birth or a crime committed in the woman's locker room, there's no men there. They are acceptable witnesses there. Based on the Quranic verse that tells you that if you're going to write a debt or a contract that you should bring 2 men as witnesses or 1 man and 2 women, because if one woman forgets, the other one will remind her. Now, the Shafi'is say this is the only situation in which you can have women witnesses. The Hanafi school of law says, no. Women can be witnesses, except they're always half the value of a male witness in any area of law, except hudud law, which we don't want to get into, and capital crime law like murder, which we, again, don't want to get into. But, so there's different approaches. One is sort of sees women witnesses as an exception, another one sees it as a rule, excluded in certain exceptions. But all of them see, in the vast majority of cases, that women are half the value of a man as a witness. Now, then what happens is, Ibn Taymiyyah, the scholar that everyone likes to hate, died 1328, or his student Ibn Qayyim al-Jawziyah, everybody likes to hate, okay? These evil, conservative Hanbali scholars, I'm Hanbali myself, right? They come along and they say, what the heck is, where did you get this? The Quran isn't talking about if you're in a courtroom and you have a dispute before a judge, women are only half the witness of a man. It's talking about what's called tahammul shahada, or basically notarization, witnessing a contract. That's not being a witness in a court, that's bearing witness to a contract. And what they say is that notions of what makes a witness reliable as a notary are based on culture. So in America, you have certain requirements that, let's say, a notary public has to meet in order to be the guy who comes to your house and stamps your mortgage, you're buying a house or something like that. You know, he has to have a little stamp, and he has to have the right, know how to fill in the forms. He has to pass certain tests. These are conventional, determined by every culture. It happened to be at the Arabs at the time of the Prophet didn't think that women were sophisticated enough in terms of commerce and debt to remember what the man was going to remember. But they said this has no effect on bearing testimony or bearing witness in a court. The Quran doesn't even talk about that. So they said, what's the difference between a man and a woman in a courtroom? They're just seeing what they saw, or they're testifying to what they know to be true. If they're a reliable, upstanding person, it shouldn't matter if they're a man or a woman. So their ruling, which is unique, is the ruling that I take as it's very well reasoned. They point out that the evidence that Muslim scholars had relied on was not, in fact, pertinent to the question they were ruling on. Thanks very much. Apparently, I've run out of time.
Well, there is a type of question that would take all night to answer. I'm glad you didn't ask such a question. But I'm sure you will agree with me that we have been well and truly rewarded for coming to hear this lecture. And we all thank our speaker.
Thank you for inviting me.
Heartily.